like to just address the issue that was raised by the member Lynn Pillay in her last call, and in respect of Clause 6, new Section 20A. Now, before I go to the details of this, there is a bit of a preamble to it. In the bill as it was introduced, the clauses prescribed what could have been a maximum time frame of up to 4 working days for a union to be given a reason for access to be denied. And in the consideration of the bill, I believe it was the member Carol Bowman raised a concern about that being unduly prolonged, and I supported that call. The officials, to their credit, realised that the initial policy intent was for that not to be the case, but somewhere in the translation from policy to the bill, the duration was doubled, and they were very happy to recommend amendments that reduced the time frame for the whole thing to be wrapped up within 2 working days. So if we then just step through the clauses as they are, bearing in mind that the goal is for any decision and the reasons to be communicated within 2 working days or deemed acceptance in that time, then the obligation is on the employer to provide a response the working day after. So if I as a union representative ask for access in writing on the Monday, the obligation is on the employer to have responded by the end of the working day following. That's the end of Tuesday. If the employer does not do that, then by the Wednesday, access is deemed to have been granted. Now, in terms of the wording of the clause, it is necessary to keep Section 20A2C referring to 2 working days, within 2 working days. So the Wednesday in that scenario is within 2 working days and works mathematically. If permission is specifically granted the working day following, then the obligation falls on the employer under 20A3 as soon as practicable, but no later than 1 more working day after that, to provide a reason why, and that would also have been the Wednesday. So in that scenario, everything is wrapped up on the Wednesday, but the Clause C that the member thought may have been out of whack with the rest of the section is in fact quite consistent with the intention that the committee wanted to recommend back to the House, and I suggest that no change to the bill is necessary.
Call Darian Fenton.
Chair, thank you. And I just wanted to add one important point to my very good colleague Marion Street's contribution, which I thought was very powerful, and I hope that the National Party were listening. But the other fundamental thing about this bill and this part, Mr Chair, that hasn't been referred to this morning is we've talked about fairness, but we're actually, with the 90-day trial period, denying access to justice. What we are saying with this bill is that people will lose their livelihood, they will lose their economic livelihood, they can't be told a reason why, and they can't challenge that reason. That is a pretty fundamental thing in New Zealand. It's a fundamental legal thing, understanding in New Zealand, that if you're treated unfairly or if something happens to you in other walks of life, you have the right to challenge it. You have access to justice. So it's I think that's one of the very strong oppositions that we have. And I want to give an example that came out this week. I know there's been a bit of discussion about the source and aioli, but there was an example that came out earlier in the week of a farm worker who took on a job as a farm worker, milking the cows, moved to the farm cottage, took his wife and 2 children with him, signed an employment contract, an employment agreement that had a 90-day trial provision in it. And he said, well, actually at the time he thought, oh, well, wasn't much to worry. He did notice it, signed the agreement, did notice it, and, but thought, oh, that won't apply to me. So he took his children and his wife to live on this farm, and the children went to the local school, settled in at the local school, really loved it, thought it was fantastic, having a wonderful new life on the farm. Anyway, a couple of months into his employment, he had an argument, he had a disagreement with the farmer, his employer. And what that was over was the way the employer, the farmer, was talking to one of the farm hands, a migrant worker actually, and he was very nasty to this guy. And so the the worker decided to stick up for him, which is what you expect people to do. If people are being bullied, it's a natural instinct to stick up for a workmate or a friend or a neighbour, and that's what he did. He said, "Don't talk to him like that, please. Please don't talk to him like that." Anyway, the next morning, the farmer came round the milking shed and said, "I'm sorry, I'm going to have to let you go. I'm going to have to let you go." And the guy asked for a reason, and he said, "Well, I don't have to tell you because you're employed under the 90-day trial period." He'd done nothing wrong except stick up for his workmate. He'd done nothing wrong. And, of course, there was nothing he could do about it because he'd signed the employment contract. So let's be clear about this. If employers get the paperwork right, there will be people that get fired like this. This Wilson hourly guy, yes, it didn't apply to him because the employer got the paperwork wrong. But employers get it right, they're going to be fired. In fact, I've heard from many, many workers in that situation. And so this poor guy had to pack up his family, leave his farm, leave the farm cottage, the place he was living in, tell his children that they were no longer going to be going to school, to the local school, and they were leaving. And he felt a real sense of shame of leaving a community he was just starting to build relations in, and had to try to explain to his children why they were having to leave, and disrupted their lives, their education, and of course this guy's economic livelihood. And the upshot of the story is actually he's gone to Australia. Now I know the opposition are going to say, well, they've got longer trial periods in Australia, but fundamentally for him it was an issue of fairness, the impact on his children, the impact on his livelihood, the impact on his career as a share milker in the future, and just the overwhelming sense of frustration and anger that we live in a country now. We live in a country where workplaces of less than 20 where workers can be treated like that, but we're going to be living in a country where every worker in the whole country can be treated in the same way. Yes, it's not going to happen, we know that. But the fact is there are employers out there, and we saw it and we heard it in the Select Committee. They wanted not just this extension to all workplaces, they wanted it to be the default provision. They want more. They always want more. And I think Kate Wilkinson does too. And in fact, I heard from another group of workers, 4 of them working for the same firm in Napier, 4 of them who've been fired under the 90-day trial provision. 4 of them.
I called